and welcome to this virtual session on the new National Framework for Penalty Notices. My name's Adam Luke and I head up the School Attendance Policy and Strategy team at DFE, and I'm joined this afternoon by Rosie Palmer from my team, and between us we're going to walk everybody through the new National Framework on Penalty Notices. Next slide, Rosie. So, first of all, we are going to do a bit of an overview of the changes themselves, and they are set out in regulations and come into force on the 19th of August 2024. And the point of the webinar is to help you prepare for those changes, and it'll give you a high-level overview of them. It's aimed particularly at school attendance staff, so people working on attendance in schools and in local authorities, but it also will be of interest to those of you who work around that in schools or governors or local authority services too. During the development of the national framework, we've worked extensively with local authorities to prepare them for the changes, because they're the overseers of the system locally and how it works in a local area. So any questions that you have specifically about your local processes in the area that you operate in the country, then you can get in touch with the school attendance support team in your local authority. Please do also watch out for updates to their codes of conduct on a local basis, and changes to their local processes in their area. We won't be able to cover those this afternoon, obviously, because they're different from area to area. The detail on what is required of both schools and local authorities, how it all fits together and what the expectations are all set out in the departments working together to improve school attendance guidance, and you'll find that on pages 56 through to page 61. Due to the timing of the general election, we've recorded this session rather than delivering it live as planned, so there won't be opportunity for Q&A in the same way as usual. But Rosie and I have included at the end some frequently asked questions that we've had lots from schools and local authorities, so hopefully we'll cover many of the questions that you may have had if the session had been live. Perfect. Why don't we make a start then? Coming over to you, Rosie, for the first bit on the purpose of penalty notices and the wider context.
Okay, thanks very much, Adam. So yeah, we're just going to set the scene a little bit now with stepping back and looking at the point of penalty notices and why we've made the changes we have this year. So the first and really key point to flag, and it might sound very obvious, but sometimes I think this purpose gets lost a bit. Penalty notices are there to improve attendance. So they're not a punishment to parents. They're not about money-making exercise. Their primary purpose is to change behaviour and improve attendance. So they should only really be used if you think they're the best tool you've got to improve attendance in that particular case. So that's the first point to raise. So as a lot of things in the school attendance world, they're set in the context of regulations. So penalty notices are an alternative to prosecution. They give a much quicker and less labour-intensive method to influence attendance. They must be issued in line with the penalty notice regulations that we've recently amended, and also with your local authority's code of conduct, which, as Adam has just said, they'll also be amending at the moment to reflect the new rules. So as a bit of historical context, they were introduced in 2007. Use was quite constant until 2016, when we had the Supreme Court case, and following that, use of penalty notices increased substantially. So in that case, a parent argued that he should be able to take his child out on holiday in term time, and the Supreme Court found in favour of the government, and as part of that case, they defined regular attendance as every day that the school is open and where no exemption applies, such as illness. So after this, local authorities increased the use of penalty notices a lot. As you know, their use was suspended during the pandemic, and they've since increased in use back to the sort of similar levels we saw prior to the pandemic. And largely that's been driven by the increases in holidays in term time. So as you probably know, most penalty notices are issued for holidays taken in term time. It was 89% last year, with about 11% for other unauthorised reasons. So as you also probably know, there's been a wide variation in use across local authority areas. So currently and up to now, and this will be changing as of August this year, local authorities set their own codes of conduct and will set when they will consider a penalty notice. So there's no national thresholds currently, and that's what we'll be seeing at the introduction of in August this year. So there's been a lot of regional variation in how they're used. So this is the sort of background context, and now Adam will move on to why we've made the changes that we have.
Perfect. Thanks, Rosie. So, as Rosie said, it's a long-standing part of the attendance system, the penalty notice. But what we heard when we were developing the support first approach that is set out in the Working Together to Improve School Attendance guidance is that the use of penalty notices often is the first resort rather than a later stage thing, and is chosen because it is quick and easy to be done. Actually, everything that we all know on working on attendance is that what really works is a support first approach, and there is no quick and easy answer. So the first principle behind the new framework really was to embed the attendance penalty notice as a useful tool in a set of tools that schools and local authorities have within that wider framework of the support first approach that the Working Together statutory guidance sets out, so that it makes sense within the other suite of things that you have. So the first principle really then is this idea that support always comes first. Legal action should only be used where that support has been tried and it's not worked, or where the parent isn't engaging in that support, or where it isn't appropriate, so support isn't needed, like a term time holiday. But the idea of the Working Together guidance is we move away from the idea of a punitive first approach or moving straight to attendance legal action to one of high support, high challenge. So parents and pupils have the ability to engage in support where they need it, and they have challenge and they face consequences if they don't do so. And similarly, if we to put our time and investment into supporting those where there's a barrier to attendance, that also means that we need to be really clear with those people who deliberately break the rules, as Rosie said, where offences are committed. And if support isn't appropriate, moving as quickly as we can to this as a tool or the other enforcement tools. So it's about, in embedding the support first approach in practice, it's about recognising that each absence case is different, thinking about them on an individual case by case basis. Is this the right tool, or the best tool I've got in the toolbox of the Working Together guidance for this particular family, for this particular cause of absence at this particular point, and using that case by case process for deciding whether a penalty notice is the best tool you've got, rather than jumping straight to that, or as some people do, never using it because it doesn't feel fair in some cases to some people. The second point then is consistency, and Rosie touched on this, but currently under the existing rules, there's wide variation across local authority areas and across schools within local authority areas, and the deterrent effect of the penalty notice and the behaviour change that we want to see from penalty notices won't be effective if it isn't consistent across the country. If you speed on a road in any part of the country and you go over the speed limit, the consequences are the same. And everybody is clear on that and are able to understand it. Currently, it varies massively what is and isn't construed as an offence in different parts of the country, and where a penalty notice is and isn't used. And if one school next door to another school issues and one doesn't issue, that isn't fair to parents in the local area. It also doesn't send a very clear message, and it undermines the deterrent. So the second point really is consistency. Being as consistent and fair for families, no matter where in the country they live or what type of school they go to, so they don't have a situation where they've got two children in two different schools, one gets a fine, there's a fine for one and not for the other, or they have a friend who's in another local authority area who's fined after having 2 weeks or 3 weeks of absence versus 2 days or 3 days currently in some parts of the country. So the second point is, how do we get the consistency? And that's the idea behind the framework and a single national threshold, which we'll come on to. The third point is that in cases where, and this came up a lot in the many rounds of consultation of developing the framework, the deterrent wasn't working in the cases where often it is most important, such as a term time holiday, because, for example, those who can't afford to take a holiday outside of term time might be unfairly penalised if they get fined where others put it to the cost of the holiday much more easily. And so the idea is that it is clear throughout that there is an effective deterrent. That meant a very small increase in the amount of the overall fine. So from £60 and £120 to £80 and £160. That's for the first penalty notice. We predict that will have some influence on behaviour, and it's calculated as being a rise in line with inflation, as had previously happened at the last increase in the penalty amount in 2012. The biggest change is to the idea of how do we break the cycle of repeat offences and make sure the deterrent it works in cases where this is happening again and again. So if the deterrent of the penalty notice doesn't work the first time a penalty notice is issued, if a further offence is committed and the threshold is met again in future within a 3-year period, the fine is charged automatically at the higher amount of £160, so it's not eligible to be paid at 80. It's always 160 on the second go. And similarly, if it is committed a third time and an offence is reached and the threshold is reached the third time in that 3-year period, a penalty notice clearly isn't appropriate at that point, because it isn't having the desired behavioural effect, and therefore something else will be expected in future, which in the case of term time holidays is likely to be prosecution, but it could be something else that is at the local authority's disclosure. Coming back to you now, Rosie.
Okay. So now we're going to go into the detail of the actual changes that are coming into effect with the changes in regulations from the 19th of August, so at the start of the next school year. And as Adam mentioned at the start, this is all written down in the Working Together guidance, so you can find more detail there, and your local authority will also be aware of the changes. So the first point is this idea of a single national threshold for when a penalty notice must be considered. So as we've said, local authorities have all had different thresholds, and we have sort of drawn this together into a single national threshold of 10 sessions of absence within any rolling 10 school week period. So there's quite a little bit to unpack in all that. So as you may not be aware, there's 2 sessions in every school day, so it amounts to about 5 school days. A really key point here, and that's something that's been misunderstood quite a bit. This isn't a trigger to issue at this point, to issue a penalty notice. It's a trigger to consider a penalty notice. So there's nothing that says you must issue a penalty notice at this point, but it must be considered. And the point of this is getting more consistency between schools and across local authority areas. So in terms of when the threshold is met, so the absence can be consecutive or not. So that might be a holiday of 5 days, a week's holiday from school, that would hit the threshold, or it could be every Friday for 5 weeks. It could also be a combination of different types of unauthorised absence. So it could be 3 days of holiday in term time plus 2 days of other unauthorised absence. And in terms of the 10 school weeks, they can span different school terms and school years. So you could have 2 days absence at the end of the summer term and then 3 days absence early in the autumn term. So there's a bit of detail in there, which, as I say, is all in the Working Together guidance. And also just to note that these rules come into effect from the 19th of August. So absence at the end of this summer term will not count towards the threshold. One final point just to be aware of, whilst this new threshold is in regulations, local authorities still have the discretion to issue a penalty notice below that threshold in an individual case if they deem it appropriate. And they will have written that into their code of conduct if they wish to do so. So if you have, for instance, a case where you think a penalty notice would make a difference to improve attendance, so you might have a family who are repeatedly taking holidays below the threshold, 4 days, 4.5 days, to avoid a fine, then that might be a case in which you could consider issuing a penalty notice in that instance. So that's the detail on the national threshold. And now I'll hand over to Adam for the next piece.
Thanks, Rosie. So the second part really is about when that national threshold is met, what happens next? And so from the 19th of August, there will be a legal requirement for all state-funded schools at the point at which that threshold is met to make an individual assessment, case-by-case decision about whether a penalty notice can and should be used. So the ideas behind this we'll walk through now, but just for absolute clarity, that is a decision about whether you are moving to a penalty notice or whether you're managing with one of the other tools that I mentioned before. It isn't a requirement at every time the threshold is met that you have to issue a penalty notice. It's a decision at that point, following the things that we're about to talk about. Do I think this is right? So it's down to the professional judgment of the school at that point. So what is that consideration then? The threshold's been met, and it goes back to the principles I was talking about at the start that are set out in the Working Together guidance. Support is the answer to improving attendance in the vast majority of cases, and legal enforcement should only be used where that support isn't appropriate, or it hasn't worked, or it hasn't been engaged with, as I said. So the first question is support appropriate? And by support, we mean anything that isn't a penalty notice or prosecution. So anything short of that, whether it's voluntary support or formal support as defined in the guidance, whether it's help within school and tweaks in school to the barriers to attendance, or it is support from outside agencies, it's things that will help the family to overcome a barrier. So is the reason the child's missed 5 days of school or 10 sessions of school something that we can help and provide support with? If yes, then the requirement is you do that. If not, is the penalty notice the most appropriate tool I've got in the toolbox? For example, if it's a really extreme amount of absence and they've missed lots and lots of time, is a penalty notice severe enough? Do I want to go to prosecution, or is it something that actually we need to think about an education supervision order or whatever else, all set out in chapter 6 of the Working Together guidance. In this idea of what happens at the threshold where you think that support isn't appropriate, I think the biggest question really then is whether there are any local authority processes as set out in the local code of conduct that you need to look at. If in doubt, always talk to the school attendance support team in the local authority. On the support side, if support is appropriate, then it is providing that activity, and it isn't that you can't come back to a penalty notice in future if that isn't engaged with or what have you, but it is doing that instead of the penalty notice. Where the support isn't appropriate and you've decided that you're going to use this tool, and you've looked at the code of conduct and you've thought about what needs to happen. The other few things that you just need to think through is firstly, is this really going to make a difference basically in this case? Is it the best tool that I've got to make a difference? If it isn't, think about one of the others. If it is, then the next thing you consider is there anything under the Equality Act that I need to consider in this particular case? And if there is, the local authority will help and discuss that case with you if you are struggling with it. Then the local authority has a final thing, I suppose, that they need to think through, which is it in the public interest to issue a penalty notice, bearing in mind that they have to prosecute if that penalty notice is unpaid. So is this case sufficiently in the public interest to take action? In the vast majority of attendance cases, and particularly where there's term time holidays, it will be, because obviously the impact is not only on the child and the family itself, but on the wider impact on the class and the class teacher of having to catch somebody up to speed for a clear breach of the law, and of course for the impact it has on the wider community, in the sense that there are so many other families who follow the rules and have chosen not to take holidays or paid more for their holidays, in outside of term time in order to be able to do the right thing. And so it usually will be in those cases. But the local authority can always advise you on those matters, and that's as I say, that point on public interest is for them to decide. I should also just say, running through the framework and the wider guidance is that idea of working together, and that includes working with the local authority. So sometimes with legal work there is a bit of a gap between school processes here and then we refer to the local authority and something happens there. I hear lots about sort of schools referring and then local authorities bouncing things back, or schools referring and not necessarily understanding how local authorities' decisions are made. We shouldn't really think about it as a sort of two-stage process. It's understanding as a school what the issues are facing that family and making sure that they get the right support or the right legal action if legal action is needed. But it's also making sure that the school in LA, that you're working together so that the family's experience is joined up. And so the ethos of the guidance helps with that, but so too do some of the tools in there, like the regular targeting support meetings that you'll have in future with the local authority, your single point of contact in the attendance team in the local authority, so that you can discuss and agree where you might be in doubt on these things. Perfect. Coming back to you, Rosie, for the third bit.
Okie doke. So this slide is all about the concept of a notice to improve. So in cases where you've met the threshold and you decide that support is appropriate, further support is appropriate, but it's not really working or it's not been engaged with. So instead of going straight to a penalty notice at that point, you can instead issue what we call a notice to improve. So this was a name that is used in one of the local authorities we spoke to. You can use your own name for this, but nationally we've suggested that this is the term you use, and it's basically a final warning to state that if attendance doesn't improve, you will receive a penalty notice. The parent will receive a penalty notice. So it's putting an extra stage in the process and strengthening the encouragement for a parent to engage in support where it's needed before that legal action is taken. We think about 2/3 of local authorities across the country already use some form of warning like this, and the impact has been shown to be quite strong. Most cases don't require a penalty notice after it, and so we see the improvement without it. So the contents of the notice to improve are set out on this slide. I'm not going to read all of it out. It's also listed in the guidance on point 187. But basically, the notice to improve should set out the detail of the absence, when it occurred, what the overall attendance rate is, something on why attendance is important and the learning lost, what support's already been offered and what more could be provided, and also detail on the time frame for the improvement that the monitoring is going to happen for, and what success looks like. What's the criteria for when a penalty notice could be issued within that warning period. So we decided, after speaking to lots of local authorities and schools, that we would have quite a bit of flex in this process to be worked out at a local level. So local authorities will set out the process for the notice to improve within their code of conduct, and they should be doing that in consultation with schools, with you. So we've recommended some flex in terms of the length of the improvement period. We think it should be between 3 and 6 weeks. That's what schools and local authorities told us were probably most effective. There's some benefits to having a longer period that shows sustained improvement, but also a shorter period demands quicker action. So that's to be worked out locally. And again, we've given some flex in terms of what circumstances a penalty notice would be issued. We heard from feedback that for some families, improvement is key and the odd absence could be tolerated if the parents are showing some engagement. You probably wouldn't want to threaten that with punitive action if they're engaging really well in support over the improvement period. Or you might say that there should be no further unauthorised absence, in which case you would issue a penalty notice before the improvement period is finished. So again, that's agreed to be agreed locally. Also to be agreed locally is whether it's issued by the school or the local authority. There's pros and cons to either way. It can be quicker if issued by schools, but it might not carry the same weight as it does from the local authority. It could upset relationships between schools and families. So there's pros and cons either way. Also important to note that notices to improve should only be used in cases where support's appropriate. So not needed for holidays and term time. For holidays and term time, you've obviously got your warnings in other ways through your school policy, and during the process for asking for a leave of absence, you would give a warning to a parent that if they took the leave, then they would receive a penalty notice. So it's only to be used in cases where supports is appropriate. And also just to mention that you don't need to issue one in every case. So there's always discretion about whether it's the right tool to use. You might want to continue with support or go straight to a penalty notice if you don't think the notice to improve will have an impact. Maybe you've used one previously and it's not worked in that occasion. So that's the detail on the notice to improve.
Thanks, Rosie. We come on now then to, I touched on these before, didn't I? But the increase in the amount of the penalty and the escalating deterrent. So as I said, the fine amount hasn't increased since 2012. So we've increased to from 60 to 80 and 120 to 160 in line with inflation, similar to what happened in 2012 from the original amount in 2007. We also aim to increase the deterrent effect for repeated penalty notices by making the second penalty notice always payable at the higher amount, so at the 160. And that means that's within a 3-year rolling period of the first notice. And then a limit. So many local authority areas currently have a limit of how many penalty notices in a 12-month period, but the new framework extends that over a 3-year period. So it limits to two penalty notices issued to a particular parent for that particular child within a 3-year rolling period, so that if it isn't changing behaviour and you haven't request and issue penalty notice after penalty notice, it isn't having the impact. So first time you've got the opportunity to pay that lesser amount. If it's done again in that 2-year period, it is always charged at the higher amount. And if it happens again, a third or subsequent times, you're thinking about what instead is done. And that hopefully breaks the cycle of offending and increases the deterrent to taking time. The escalation applies to the same parent. So it's when the same parent gets a penalty notice for the same pupil. So if a parent receives a penalty notice for one of their children, and then they receive a second penalty notice for that same child within that 3-year period, then the escalation continues. If a parent receives a penalty notice for one child and then they receive a second penalty notice for another child, that wouldn't count towards the escalation. It's based on one parent, one pupil for the same parent. That doesn't mean, of course, if both those children went on those two on the same period of absence, that they couldn't both have received a penalty notice the first time, and therefore both will be charged at a higher rate the second time. The other thing to bear in mind, I think, on this, I won't go through everything, but the other thing to bear in mind on this is the idea of on the third or subsequent times the threshold is met, the local authority's policy in your area in their code of conduct will set out what considerations will be made and what will happen. Something has to happen, and the default position, obviously, in the escalation will be prosecution, but there is the opportunity where local codes of conduct set it out for to consider other things, and that would be sensible in certain cases. But in a classic term time holiday case, there isn't really another form of support that could be provided. Support wasn't appropriate in the first place. There isn't really another form of legal action that could be taken other than prosecution, so it is likely to be prosecution. Perfect. Handing back to you, Rosie.
Thank you very much. Okay, so the final part of the framework So it's long been the case that schools and the police can issue penalty notice for absence as well as the local authority. If they do that, we've also put into regulations that they must check with the local authority before issuing a penalty notice. And this is just to make sure, I mean, we think this would happen anyway, but it's just to make sure that there's no duplication of penalty notices, there's no other prosecution cases ongoing that the school doesn't know about, and to check there's agreement around whether sufficient support's been provided before issuing that penalty notice. Okay, so now we will move on to some examples that we've worked up just to bring it to life a bit more about how the new framework would work in practice. So over to you, Adam.
Perfect, thank you. So we'll come to this first example of a Year 7 pupil with sporadic unauthorised absences at the start of the autumn term. The schools picked that up early in their data monitoring, and the head of year for that pupil has had a phone call with the parent to ask if support is needed, and particularly asking, is there anything around the transition to secondary, and explain to the parent the importance of good attendance habits. We mustn't forget that bit, because whilst we're not out to blame parents, it is often the case that we need to translate what some of the time missed from school actually means for a pupil. The parent is set out to the head of year, in this case, that it's a matter of getting used to the new routines. The absence continues, and that improvement isn't seen, and that means the case meets the national threshold. Because they're saying this, it's a continued pattern, the school invites the parent into the meeting. The parent attends that and shows some engagement in improving attendance. The school thinks that in this case, maybe we look at a notice to improve, given a period of 4 weeks, over which they want to see an improvement to the extent that there are no unauthorised absences in that period, and they think that that is a likely and fair way to deal with this, rather than jumping straight to a penalty notice. The local authority issues that notice to improve. The parent and pupil really latch onto that, and no further unauthorised absences are taken in that monitoring period of 4 weeks, during which the school's been monitoring it closely and making sure that attendance doesn't drop off. So in this case, it was clear, wasn't it, that support was appropriate, there was some help needed to be able to build a confident and good relationship with the family and with the pupil, explaining why it was important about that attendance and punctuality, and making it clear what the consequences were if that didn't continue. The school needed that needed that nudge of the notice to improve, but they felt that that was a better thing to do than jumping straight to a penalty notice, and it does work, and they're monitoring it to make sure it doesn't drop off for the rest of the term. So that shows you an example of where perhaps in the past we jumped straight to penalty notice, but here with the notice to improve and delving into the toolbox that is in the working together guidance, a nice positive outcome was needed without criminalising a family. Next one, Rosie.
Okay, so this is an example of a pupil with quite poor attendance over the school year, and in the spring term they've hit the national threshold. They have 10 sessions of absence within 10 school weeks. So the school's done quite a bit of engagement with the parents already. They've had a few phone calls. Parents are struggling a bit with routines and boundaries at home, and there's also some wider issues at home to do with housing and finances that are causing some of the issues around attendance. So here's a really obvious case where more support is what is needed, not a penalty notice. So the school decided to offer an early help assessment, and the family accept it. And so you see how the need for legal action is avoided, and you've got some positive work with the early help team and the school happening there. So as you see, with the point we're trying to make here is that, often in these cases it's not a penalty notice that's required, even though the threshold for absence is met. So Adam, leave of absence.
So this one's a nice clear-cut case, one that I'm sure you've seen before. The parent has applied for a week leave of absence for a family holiday in term time. The school's turned that request down and set out the reasons why they've done that. The family take the holiday anyway, and that absence meets the national threshold. And the school considers that a penalty notice is the most appropriate tool they've got in the toolbox because support isn't appropriate. None of the other tools feel relevant. And they believe that it will change they hope it will change future behaviour and prevent further term time holidays, both from that family and elsewhere in school. And so the local authority, they make the request to the local authority, who reviews it and issues the penalty notice to the parent and warns them that in future it will be charged at a higher amount or ultimately prosecution. So a really clear-cut case where penalty notice is appropriate. It shows how it's not just the penalty notice that does the work here, but it's also all the communication around it, the warning, the conversation with the school, being clear on what future action and future consequences there might be. All the time we're trying to change and influence future behaviour. Back to you, Rosie.
Okay, this is the last example now. So this is also absence due to a family holiday or visiting family abroad, but it's much more extended. So we often hear cases of long bouts of absence, maybe up to 4 weeks. I know people find this really difficult to deal with. So in this case, there was a similar case in the previous year. An absence of this sort of time was taken. A penalty notice was issued then and it was paid. The school tried to talk to the parents about their legal duty and the learning that's been lost and the implications sort of on the curriculum time and the rest of the class, but the family didn't really engage in that at all. So in this sort of case, you might consider that there's not much point in issuing another penalty notice. You'd probably see the same result again. It would have no impact on attendance. And you might even think that the higher amount for a second penalty notice wouldn't change behaviour either, because the absence is so severe and it's been done before. So this might be a case in which you'd consider going straight to prosecution, asking the local authority if they would agree to do that. But again, as I mentioned, this is a lot about the school working together with the local authority to weigh up together what's the best way forward. Because, in all these cases, the school has the knowledge of the family and the local authority has that sort of overview of what would be worth prosecuting in court. So there's a few examples just to try and bring it to life a bit how the new rules around penalty notice will be working. So over to you, Adam.
Perfect. We'll move on to questions and answers now. And as I mentioned at the beginning, what we've tried to do, Rosie and I, is sort of capture up the questions we've been asked when we've been out and about and when we've been running sessions with local authorities, so that we can try and answer the sort of common questions that have come up. Let's make a start, Rosie. Next slide. So this first question, should a penalty notice be issued every time the national threshold of 10 sessions in 10 weeks is met? How should we make the decision? I covered that earlier on, didn't I? But the short answer is no. It isn't a sort of trigger point at which you always issue. It's a point at which every state-funded school has a legal duty to consider, in this individual case, is it right that we issue a penalty notice, or are we doing something else to support that? As we've seen in the examples there, in some cases it's really obvious. The parent requested a leave of absence that was turned down. They went anyway. A penalty notice is likely to be the most appropriate. In others where consideration is needed about support first and thinking about whether support is appropriate, it's coming back to this idea I was talking about earlier of this is my suite of tools in the toolbox and which one is the most appropriate in that case. And if in doubt, talking to your local authority team. Second one, can we choose to not issue penalty notices at all? Nice, easy answer to that. No, as I've said, all state-funded schools have that legal duty to consider on an individual case-by-case basis. So You can't take a blanket position that will always issue. Likewise, you can't take a blanket position that will never issue. The national system really won't work, and it'll be unfair to parents if some schools issue and some don't, and if those blanket positions happen. It's not about upsetting a family, and what I hear sometimes from schools is we don't want to do that because it'll damage our relationship with the family. It's very clear, and DfE's made it really clear for parents. These are the rules. There is the exceptional circumstances judgment that can be applied in cases where a parent generally does need to take leave. Where support is appropriate, the new framework means that the support will always be provided. But on the flip side of all of that, when that isn't appropriate, or when you've been through that and it hasn't worked, the deterrent and the enforcement action needs to be there, and it needs to be applied consistently across the country. Otherwise, it won't work. So please remember, in doing that legal duty, that in evidencing on that individual case what the right action will be, sometimes that will be a penalty notice. Third question, has DfE policy changed on holidays in term time? No, the exceptional circumstances judgment remains, as I talked about earlier, but a crucial thing to remember in the new version of the guidance is a clearer articulation of what a holiday is. So I know that has been a point of discussion for some schools with certain communities and certain people in communities about what is and isn't a holiday, and it's defined in the new statutory guidance as a period of recreation or leisure. So it doesn't have to be a trip abroad or away from the home. It could be a day at a theme park. It could be visiting family or whatever. It is defined as a period of recreation and leisure. So usually a period of recreation and leisure, a holiday, won't be an exceptional circumstance, and that's a national position. But the school retains flexibility in really exceptional cases, and we can't provide a list of those because they are so individual to that particular family and school. Question 4, what other methods can we use to reduce holidays in term time? There are a few, and I will come on to that, but I just wanted to make a couple of points, and this bit on the slide is really helpful for this. We return often, don't we, to this question of what is the impact of a term time holiday? And I hear that from parents, and we read that from parents, and I'm sure you do too, otherwise really good attendance. But back when this was first looked into in 2013, 2012, 2013, there was some work done that showed that where a parent takes a child out of school for a holiday every year, and we've updated the statistics for the new threshold of 5 days, but where a parent takes a child out of school for 1 week of holiday every year of their school career, and that child has the average number of days of illness-related absence that children will have, by the time they've finished school, they will have missed 2 terms. And that figure, if it's a 2-week holiday, is they'll have missed a whole school year in comparison to their peers. So it is really important that we think about how we encourage schools. So we encourage parents not to take those holidays in term time, and where they've decided that they are going to take one, how we think about what we can do to not only set out the negative implications of doing so for their own children, but to be really clear on what the impact is on the wider community, not just on the other parents and pupils who've done the right thing and followed the rules, but on them having to miss things to catch up for their child, and so on and so forth. And some of the most effective schools in this have sort of tried to practice what they call damage limitation. So if a parent is really clear that they want to take a holiday, thinking about, can we help to reduce the time, and if they were going to go for 2 weeks or 3 weeks or whatever, could you go for a shorter period to reduce that? Is the work that you could take with you so that you don't fall behind? Is there things that you can do in terms of your timetable in school so that it discourages that it hasn't got as many broken weeks, so it discourages people from taking holidays over where they perhaps have to be in school 2 or 3 days in the week because there's a bank holiday or an inset day or whatever. So it's thinking about other things that can be done there. The fifth question, will there be any variation between councils in approach? So not in the national standard threshold, that's the same across the country, and we've explained why that is the case. There will be in terms of local processes of how things work, which I mentioned before, worth getting familiar with the code of conduct, but there should be similarity and in the majority of areas across how that operates. The other thing that will change on an area to area basis is what the support looks like in deciding whether support's appropriate. Obviously, similar things will be there in terms of early help or access to transport or send or access to parenting programs or what have you, but they will look different, and the thresholds for those things are often different on an area by area basis. So those are the areas within it that you need to sort of think about what is our local view, and information, first stop for information on that is the code of conduct in the local area, or talking to the point person in the attendance support team, as we've talked about. The sixth and final question on this slide then is, what happens if we want to issue a penalty notice for a holiday, but a sibling in another school is not getting a penalty notice? I think we should try and avoid this where we can. The first thing is talking to one another as schools, or asking the LA to talk to the other school if you know that the child has a sibling in another school, so that you can take a similar approach. That won't be possible in absolutely every case, and you're not going to get that perfect in every case, but we should, with applying the same national threshold and considerations, it will usually be that hopefully you reach the same decision and talk to one another to try and make that as effective as we can. And then local authorities are a sort of third check on that too, where they're seeing that there are siblings, that they could have that conversation. Over to you for some more of them, Rosie.
Thank you, Adam. Okay, so next question. If a pupil reaches the threshold of 10 sessions quicker than the full 10 weeks, do we have to wait for the 10 weeks to issue the penalty notice or the notice to improve? So the quick answer to that is no, you don't. You don't need to wait. So if, say if a week of school is missed, then you could issue the penalty notice straight away. You don't need to wait for the full 10 weeks. So the action can be taken as soon as the threshold is met. So the next question, will the DfE daily attendance data tool be able to monitor the 10 sessions within 10 weeks? So the short answer to that is not yet. We're exploring options of how it might do that and how it can support schools and local authorities to meet this particular statutory duty. And we will be contacting users of the service once it's available. So next question, do penalty notices from this year, so 23-24, count in the escalation process? When do the rules start from? So we've had a few letters in from parents asking about this. If we've had 2 penalty notices this year already, will we be prosecuted if we take a holiday in the autumn term? So the answer to this is no. So the slate is starts clean at the start of the 2024 academic year. So previous penalty notices will not count in the escalation. So all these new rules start from August the 19th, and prior penalty notices will not count. Next one, I think, Adam, you've already covered this, but just to reiterate again, so how does it work if a parent takes 2 children out on holiday at the same time? 2 penalty notices are issued. So as Adam said, the escalation applies to an individual, to a parent in respect of an individual child. So they would both be issued at the same rate of £80 paid within 21 days and £160 paid within 28 days. If both children were then taken out on a further holiday, then it would be likely that they would get, at the second offence, if another penalty notice was issued, then it would be issued at the higher rate. Third question, we've had this from a few schools who are reluctant to prosecute on a third offence within 3 years. So no, you don't have to prosecute on a third offence within 3 years, and the local authorities and the independent prosecutor, it's always their decision as to whether to take forward a prosecution. But as Adam mentioned, some action must be taken, and this will be set out by your local authority in their code of conduct the things that will be considered if the threshold is met for a third time and 2 penalty notices have been issued previously. So it's always thinking through in these cases to come back to the same point again and again, what's the best available tool in the tool bag for these cases? What's most likely to improve attendance? Most likely it would be prosecution at that stage if the offence has been repeated over a number of times, but it might be something else that you deem more appropriate, maybe an attendance contract, an education supervision order, and all these things should be discussed with your local authority. Okay, next slide. I think this is the last one for you, Adam.
Yeah, lots of questions for people, aren't there? What can we do if a parent repeatedly takes holiday in term time below the threshold to avoid a penalty notice? I think this is really important that we keep the message out there that any, as Rosie mentioned before, any day or session of absence that hasn't got a statutory exemption as set out in section 444 is against the school rules and is likely to constitute an offence. So in any one of those cases, the local authority can choose to use their discretion to take legal action. So it isn't the case that just because the national threshold isn't met, a local authority can't take action in an individual case. So there is discretion there for individual cases, and this is the type of case, isn't it, where there is a pattern of behaviour that is very clearly trying to get around that national framework, where you may want to be able to talk to the local authority, say in your target and support meeting or other regular meeting, about whether actually we move to legal action in that case. 13, why are you allowing flexibility in the notice to improve process? I think you set a lot out on that, Rosie, didn't you, really, in how it should look. But I think it's back to this principle of what is the best tool in this individual case. We don't want to put another step in the process for you that delays action happening if you don't think that's going to work. But actually, if you think what is needed is a nudge to the parents that this is becoming serious, and if we don't start to see improvement, then we will move to this action. We know, as Rosie said, that in many cases that is effective. So if you think that is useful, it is another one of those tools in the toolbox. So we're allowing that flexibility to use it if you think useful, and not in cases where you don't think it is useful. Next one, what happens if the school believes all possible support has been provided and wants to issue a penalty notice, but the LA disagrees if the parent requests different support? Simple answer on that is it's the local authority's decision that is final on that stuff, as the independent prosecutor, as Rosie has said. It will depend on what is available in the area, so it's not obviously a wish list of every possible support that anybody can think about. It is, what are the tools that are available to you, and have you used those that you're considering within the realms of possibility? But LA final decision on that. Question 15, this is a looser threshold than our current one. That will be the case in some areas. Won't that make absence worse? I mean, again here, for a national system to work and for the consistency and the aims we talked about at the beginning, moving to that means that ultimately some people would have to come up and others would have to go down to ensure that consistency of approach. But hopefully the national framework and the consistency that brings in itself will act as a deterrent. But as I said at the beginning of this slide, if parents are deliberately taking breaks around that threshold, or you're seeing people who are taking lots of shorter holidays and things, the LA discretion is there to take action in those cases. 16, is there an upper threshold where a penalty notice is not appropriate? So the national framework doesn't formally include that, but many LAs, I suspect, will adopt one based on that principle, back again to what is my best tool. If a parent has gone for a really prolonged absence or a really serious absence, a penalty notice is unlikely to be enough to change behaviour, and it may be that you jump straight to prosecution. So yes, in practice, I think people will often have an upper threshold where they think, actually, at that point we go to prosecution, but doing it on a case-by-case judgment. And final question, is there any guidance we can share with parents? So the short answer to that is the best thing to do is to go onto the Education Hub and have a look at the Fine for Parents for Taking Children Out of School, What You Need to Know page, and that can be shared with parents as well. It's written in a parent-friendly way. Perfect. Anything else you want to add, Rosie?
Nope, I don't think so. I think that brings us to a close.
It does. There was one, I think there was one final thing that struck me sort of as we were going through, and that was I've had the question from people about penalty notices for pupils who've been excluded, found in a public place during the first 5 days of exclusion, which many of you who've been around for a while will know is another one of the education penalty notices. And just some people are confused about whether the amount has increased and whether that counts as the escalation. But the simple answer is no. They operate separately to the attendance penalty notices, so it isn't impacted by the increase in amount, and it doesn't count to the escalation.
Lovely.
Super. We will finish there, and thank you very much for your attention, everybody, and thank you for everything you're doing to get ready for the changes in the law. Good luck for the new school year when it begins. As we've said throughout this isn't the only bit of information that's available. Working Together Guidance has detailed information, and your attendance support team in the local authority can support and help you if you've got questions or you're confused by any of it. But yeah, thank you once again and have a lovely day.